Hi, everyone. Good morning, good afternoon, good evening, wherever you are. My name is Brinda Bhandari, and I'm very excited to introduce you and welcome you to this session, which is titled Suing Big Brother, Strategic Litigation Outcomes Against Surveillance Laws. We have a very exciting panel with one panelist member who is just going to join because she's in another session right now. But meanwhile, let me just give you a very quick round of introductions. So today we will be discussing all things surveillance and litigation related to surveillance. So whether it's Clearview facial recognition, whether it's litigation around Pegasus, litigation around digital IDs, phone surveillance, that's part of what we're going to discuss. We're going to discuss some of the challenges that litigators face. What are some of the opportunities? How can we collaborate across, across communities, across society, across countries? So these are some of the exciting topics that we're going to be discussing. My name is Brinda Bhandari. I am a lawyer in Delhi, and I'm also the off counsel for the Internet Freedom Foundation. We've done some litigation around Pegasus in India and around reforming India's surveillance laws. We also have Zachel Zota, who's the director and co-founder of Just Futures Law. Zachel and her organization have done really interesting work around the Clearview litigation, as well as litigation around data brokers in the US. We also have Nora Bagati, who is a legal officer at the Open Society Justice Initiative. Nora works on litigation around surveillance in Africa. She's done a lot of work around digital ID surveillance challenges, as well as a case in Kenya around phone surveillance. And I believe Nadine has also joined us. Great. We have Nadine Al-Nemer, who is with the Gulf Center for Human Rights, who has also done a lot of work around Pegasus. So welcome, everybody. We would love it. Please post your questions. We want to make the session as interactive as possible. So please do post your questions on the chat box so that we can take them either while we're doing these, while we're all speaking to each other, or when we open it up for Q&A at the end. So I'd love it if it's super interactive. But maybe just to let the speakers introduce themselves and maybe give us a bit of background about the litigation. Sejal, do you want to go first?
Sure. So thank you for that kind introduction, Brinda. Just Futures Law is an organization that supports immigrants' rights and racial justice community groups with carefully legal strategies that fight the use of surveillance technologies that are being weaponized by both corporations and government actors to violate the rights of Black and Brown communities. And so at Just Futures Law, I oversee our litigation that we're building. And I'm very excited to be here today in conversation with all of the esteemed panelists, also the audience members, sharing strategies, sharing lessons learned. So, I mean, I think probably, I'm talking to preaching to the choir here. Most of you would probably agree that surveillance technologies in the last decade have unveiled themselves before us in ways that are terrifying and in every way unaccountable. I think particularly corporations and law enforcement have ignored the threats that it poses to civil rights, to privacy, core democratic values, and the rights of overplaced and immigrant communities. And so at Just Futures Law, we think it's really important to hold both of these entities accountable. And so one example of this is our work against Clearview AI, which is a US-based facial recognition company. It has built one of the most frightening facial recognition technologies by scraping billions of images from all over the internet, right? Social media, news sites, anywhere where a face might appear. And so they use these images as training data, but also to build this massive facial recognition database. But the majority of us don't know we're in the database because Clearview doesn't ask for our permission. They don't ask for our consent. And they've meanwhile provided thousands of government agencies access to its database, which could be used to identify people with dissident views, monitor their associations, track their speech. And I think, really like the scale of the database is terrifying. The company has reportedly collected 20 billion photographs, right? That's the equivalent of nearly 3 per human on the planet. And so this really is mass surveillance. In the US, we and other groups have filed lawsuits, largely by private individuals, The central claim in most of these cases, and not in ours, but in most of the cases, is a violation of Illinois' biometric privacy law, which is considered among the strongest in the United States because it both requires consumers' consent and it actually empowers consumers to directly sue companies, which is rare in the US. We are counsel in a case that we brought in California under the state's consumer protection laws, common law, and state constitutional privacy laws. And the plaintiffs in our case are activists, including immigrants who've engaged in political speech that is critical of the police, that is critical of immigration authorities. They include both individuals and the community groups Mi Gente and NorCal Resist. And for them, the ability to engage in political speech that is critical of police, free from the threat of invasive surveillance, it is really central to who they are. And so, I mean, that's really sort of the heart of our case. We also sued local police for their use of Clearview based on free speech claim and aiding and abetting Clearview. I'll note that these various lawsuits are all in different postures. To date, I should knock on wood, Clearview has been unsuccessful in having any of the cases dismissed. Many are moving through discovery, one has settled. And I'd say this is a central theme in these cases are that most of the claims are brought under state law because in the US, we lack meaningful federal privacy protection. So it may also be that the relief we see may be piecemeal, and it's really a very inefficient way to bring litigation. I'll also note that internationally, we've seen several countries order Clearview to delete their residents' data and fine the company. I don't want to take too much time, so I'll just briefly mention some of the data broker work we're doing. Data brokers are companies that collect your data, maybe aggregate your data, and then they turn around and sell it to other private companies or to government agencies. And through data brokers, we've seen that US immigration authorities, they've created a system where they can bypass warrants and court oversight, that they're basically able to buy sensitive and expansive data on any of us instead of going to a judge and having to actually go through process. And this is what keeps data brokers in business, right? They have these very lucrative government contracts. And so, this is a real priority for our organization. And so with community partners, we've been thinking through and developing strategies to challenge data brokers, whether that's developing and passing policies at the local level to block this data sharing, or actually developing affirmative litigation, where we're considering a number of strategies. So I will end it there and pass it back to you, Vrinda.
Yeah, maybe just one follow-up question before we move on to Nora and Nadeem. Could you just elaborate maybe a bit? So you said in Illinois, it was under the biometric privacy law. In California, you've gone under consumer protection law. Does the claim change based on the kind of law you're going under? I mean, so have you found that the claims against Clearview are actually distinct because, somebody's focusing more on a consumer privacy angle and somebody's focusing more on a biometric privacy angle? And then connected to that, have you had problems, has there been an active effort of coordinating across jurisdictions, coordinating the lawsuits, or have they sort of proceeded independently?
So those are great questions. So the elements of the claims do vary. And so an example is with Illinois' biometric law, you don't actually have to show an economic harm. But with California's consumer protection law, you do have to show an economic harm. And we know that in the surveillance context, that can be really hard because often the injuries to people who are communities who are being surveilled are an invasion of privacy and mental anxiety, fear of deportation, chilling of speech and association. And so for example, that would be a distinction that you see. And so the elements really do vary. And I would say with respect to the coordination piece, one of my pieces of advice for anyone doing this sort of litigation is, I mean, I think, Vrinda, as you're suggesting, is like where you can coordinate, do it. If a bunch of you are suing the same defendant, if they're similar, if there's like a similar factual question, if it's a similar issue, one thing we've done in the US is enter into common interest agreements, which really, allow you to share information without breaking confidentiality, and so then you can share tactics and research and discovery and records and not in the Clearview example, where I would say that has not been a coordinated effort, but in other cases that I've been involved in, sharing those strategies I think are really key, especially where like this is litigation that requires a lot of resources. And so I think where we can share resources with each other, where we can share expertise, where we have common goals, I think we're all going to benefit.
Thanks so much. We do have some audience questions, but I think we'll do that once we go through a round. Nora, would love to hear about you, all the litigation that you've been doing around digital ID, specifically in Africa.
Yeah, thank you so much. And it's really exciting to be in this group and be able to speak on this because, as Sejal said, I think collaboration and coordination is so important on all these things. And you can see on how they're really different issues, sort of how the themes are similar around what you witness with these surveillance cases, what you see in terms of the communities that are most harmed, the communities that are most affected by this, and then also in terms of oftentimes whom we're facing in this. And I think digital ID is a good example of where governments and corporations have sort of are really working closely together in rolling out and pushing out these systems that can really be quite harmful to the individual that then doesn't have the same kind of power to stand up against that. And so on that, actually, I think it'll be, I'll say a bit. So as mentioned, I work as a lawyer with Open Society Justice Initiative, and we work on a range of cases internationally. But the digital ID work in Kenya, I think, is really interesting also in terms of how we got to it and how the case developed, because we had been working for a very long time already as OSJI, had been working with communities, sort of marginalized communities in Kenya who had been struggling with access to identity documents, identity documentations, and who were essentially made stateless often in their own country. And we've been doing that work for a really long time. And then in late 2018, Kenya rolled out this new sort of amendment to the Registration of Persons Act. Try to snuggle that in there, basically saying we will now roll out a digital ID system very similar to the Aadhaar Indian system, which some of you might be familiar with. So really comprehensive. Basically, you need it to access all kinds of, all your goods and services, all basically both state and also certain private services would all be running through this digital ID scheme. And the aim was to collect large swaths of biometric data, of course, and also at the time, the proposal was also DNA and GPS data as well. So it was really comprehensive, really expansive. And it was actually the community groups, the ones that had been working on these ID issues to begin with, that said, hold on a second. So what does that mean for us, and sort of to what will happen to us who already don't have the same access to identification if now you have this digital ID that's needed for everything? How will we get our services? And so we worked with these groups, Nubian Rights Forum specifically, and then we're also joined by the Kenyan Human Rights Commission and the Kenyan National Commission on Human Rights in bringing a case challenging the Kenyan digital ID system at the High Court in Kenya. And we got in early sort of 2019 in April, got interim measures sort of saying this, you can't make it mandatory at this stage, you can't collect DNA and GPS data. We then had oral hearings in the case later in the year in August and October. And I think those oral hearings, I think this is something, again, that people who litigate in this area will be really familiar with. It's very hard to get, to get the technical information over to an audience, right? Both the oftentimes the people who are affected by this type of technology, but then also to the judge who decides on these cases. And so we work very closely with technology experts, also from India as well, who had been working on Aadhaar, who had been familiar with the litigation there, which of course we were really inspired by as well, and worked closely with lawyers who have been working on that. So essentially, the oral hearings, I think, were a really important step as well to bring this, to bring the conversation out into the public space. The community, again, the work that the community organizations did in this litigation to sort of keep the community as well involved, to keep them up to date, to say, this is what we're doing, this is what the case is doing, this is what the technology is doing. All this kind of engagement was really important. It was so, I mean, I still smile when I think about it, how many community members we had actually just in court really invested in the case. And so that was amazing, and it I think really sparked a conversation around these issues in Kenya that was quite inspiring. We then got a sort of mixed, I would say, mixed judgment in early 2020, which essentially also found no DNA, no GPS data, which of course is great. It also found that there essentially was a lacking framework around the data collection, the biometric data collection around digital ID systems and in the system, and that there needed to be a stronger framework governing this. In my opinion, and part of why we eventually went and appealed the case, the judgment wasn't strong enough on sort of the architectural design still of the biometric system, the way in which the architecture really, is the thing that essentially creates the exclusionary aspects in terms of people who can't register in the system. It is also, of course, the thing that creates the surveillance aspects, which we're talking about today. And so the judgment wasn't strong enough on that. We went to appeal, and I think this is again another thing that probably many of you who are working on litigation in these cases can attest to, is courts move slowly, right? And this is the case in many jurisdictions. And so we are still waiting for our appeal to sort of move through the courts, even as Kenya is actually looking at instituting a whole separate act to govern this. And so one of the challenges definitely has been, I think, and it'll be interesting to talk about that. One of the things we need to do is sort of, tackle this from various angles. The court of law is one sphere, but we also really have to engage through other ways as well if we want to take on sort of these big machineries. Yeah, so excited to talk to everyone.
Thanks a lot. I think, yeah, your last comment on sort of working as litigation as just one of the areas which we tackle is something I'd love to hear everybody's views on. But maybe the follow-up question that I sort of wanted to ask you. So we saw Sejal also talk about the difficulty in showing harm, right? Or in sometimes demonstrating harm. So I had the experience of working with the Aadhaar litigation in India, and we kind of failed to show the surveillance harm in a manner that the court was convinced. So I was wondering, did you have, what was your experience in demonstrating the harm of surveillance using the digital ID system in Kenya? And did it help that you were working with these community organizations and the Human Rights Commission? Did that help in advancing the surveillance argument?
Yeah, so I mean, it's a great question, because I definitely have, we had the same experience in terms of the difficulty in showing the harms, especially in a system that is yet to be implemented, right? This is so sort of with a system that isn't yet operational. The good thing is that the Kenyan legal system is quite flexible in, and so there we had, I think that was positive for us. It's quite flexible in allowing sort of to bring in future harms and risks sort of and into litigation and suing on the basis of that. I think in terms of the surveillance aspect specifically, and bringing that, showing what the harm is and bringing that to the court, I think a key thing, as you say, working of course with the community groups, but also really the technology experts involved in the cases and having them speak in court. So we worked with a really great cybersecurity expert, and he testified. He provided sort of written statements and testified in court as well, and I think was really able to sort of highlight through, I think now of his, and I'm not going to, go into too much detail about it, but like the models he used in court to explain everything. And, even as part of the legal team, really in going through that with him in detail, we learned so much more about what the surveillance angles of the system would mean. And it was really great to see. We also had a witness statement from Privacy International, experts there as well. And that was something that the court cited and really relied on in their judgment as well, and in finding that there wasn't enough safeguards in the system. So yeah, I mean, I definitely hear you on the struggles and the difficulties with it, but and especially as the system isn't operational yet. But again, I would say really working with experts, trying to get as much of the technical information out there is really what made the big difference here.
Yeah, I think it's an irony. For those who don't know, the Indian expert who went and deposed in the Kenyan system, like we were trying to put his testimony before the Indian courts, and actually the Indian court didn't really consider any witness statements or any evidence. So it's a bit of an irony, unfortunately for us. But moving on, Nardine, really excited to have you here as well. So you work in the Gulf and the Middle East and North Africa more generally, and you've also had some experience with Pegasus. Would love to hear more about your experiences as well.
Thank you, Brenda. Experiences with litigation, like I haven't been involved particularly in any cases, but I've been involved greatly in one branch of our advocacy work where we rely on legal analysis to be the basis for hopefully cases. And one of the things that we've realized that there are problems around the definitions, problems, as Nora pointed out, to proving harm, even if it's really eyesore. So I want to focus on Pegasus. I'll give a timeline of what's happening, some of these harms and what they look like. It's going to be a messy timeline just for the case of tracking where exactly we have seen moments of harm and how evident it was, but at the same time, some responses which involved litigation around that. And following from that, I'll tap briefly into Project Raven by the company Dark Matter that's based in United Arab Emirates, and some of the challenges that come from that type, where it's not a matter of just export, like spyware export, but also expert of expertise where these spyware and infrastructure for surveillance is developed in-house. But the main thing that we try to focus on our work is that the main targets of these tools, the main targets of spyware and all of the exploitation that could come out of it are human rights activists, women's rights defenders, journalists, and lawyers. All the people who stand up to the malicious things that happen to wars and have very noble causes when it comes to protecting and speaking up for minority communities and speaking against corruption, etc. So what we can see is not just a chilling effect, but at the same time, most of the countries that endorse and host the companies that export the spyware that's used to frustrate efforts of democratic resilience and aspirations in this region are democratic countries. And what we really want to capitalize in our advocacy is that there is some sort of international community support and reliability in that area, where one democracy should not be nourishing the activities of an industry that's frustrating like a democratic aspiration in other parts of the world. When it comes to Pegasus, it's a worldwide network of frustrating any efforts of accountability, scrutiny, or democratic resilience. We see Pegasus targeting all these actors that I just named, activists, lawyers, and journalists in Saudi Arabia, in Bahrain, in the United Arab Emirates, Morocco, India, Rwanda, Mexico, Kazakhstan, and a few more countries that I didn't note. In the region, the most drastic moment was the killing of the journalist, the Washington Post journalist, Jamal Khashoggi. Jamal's devices were targeted by a number of spyware, and one of them was Pegasus. In fact, after the killing of Jamal Khashoggi, Amnesty in 2019 supported a law. Well, it was a petition to actually rescind the license, the export license of NSO Group, which is the company that produces Pegasus or exports Pegasus. in 2019, and this was a petition directly for the Ministry of Defense. In November 2021, Apple actually sued NSO and its parent company, Q Cyber Technologies, as a way of actually demonstrating to its customer base that it's very secure, they can't exploit that backdoor anymore. And there were some consequences for that case, but we still yet to see what's happening there and what's going to come out of it. And to borrow the words of Nora earlier when she said, courts take time. In January 2022, so a bit later, wasn't much later, a few months later, we learned that 2 women's rights defenders in the region, in Jordan, particularly Hala Hadib, and in Bahrain, Ibtisam al-Sayegh, were also targets of Pegasus spyware with complete control over their devices. Now, what's really bad about this, the harm here is that, and content warning of sexual violence, is that Ibtisam al-Sayegh was targeted by different members of the Bahraini authorities, threatened publicly with rape and defamation, and having access to her private phone and private data with sensitive resources as that really augment this. So it's a matter of actually terrorizing activists on different fronts, which is definitely exacerbated by spyware. Now, a bit later, we know that a few members of the diaspora, particularly the Saudi diaspora in the UK and Canada, have been targeted by Pegasus spyware as well. Namely have been Ghanem al-Masiri, Yahya Asir, and Omar Abdelaziz. And these were all people who have been critiquing the government for long from Saudi Arabia and even in the diaspora now. A few of them were able to level a lawsuit against NSO for the misuses of spyware in their case. And that was a case that was filed by Binsman in the UK in April 2022. In April 2022 as well, Citizen Lab released a report about a widespread use of Pegasus spyware in Jordan. And it was a very cleverly titled report called Peace Through Pegasus. And it really details the profile of the people who are targeted are activists who are calling out the implications of government corruption and human rights abuses. We take a step back from this and look at Project Raven, which is, it's not a straightforward dynamic of an export, a spyware export, but in fact, a transfer of expertise where ex-members of the National Surveillance Agency in the US came to the United Arab Emirates to build these capacities in-house. In some cases, they were sued as individuals and they were sued as a group as well. But this operation were particularly targeting human rights defenders in the region. One of them is actually the co-founder of the Gulf Center for Human Rights, Ahmed Mansour. He was targeted in 2019. And we know that movement, information, messages and whatnot were actually traced to level allegations against him and make grounds for incarcerating Mansour. And similarly, that was the case for the women's rights defender, Lujain al-Hazloul in March 2018, where also her movement were tracked using software that was developed by Project Raven. And so she was arrested in Abu Dhabi in the United Arab Emirates and sent back to Saudi Arabia for prosecution for speaking up for this profile. There is a case that is raised by the Electronic Frontier Foundation in support of Lujain and the harms that she's had to endure as a result of being targeted in that way. And we yet to see what's the outcome of this. And that was a lawsuit that was filed in 2021. So this was a snapshot of some of these big moments of harm, but also what kind of lawsuits that could be leveled. I think one of the things that we really need to acknowledge is that we really depend on activists' willingness to level this, to be public about it. And that's not something that everyone can afford. In fact, here I'd borrow on Lujain's very brave words and saying it's a privilege to be able to be public about this and actually level a case against people who've done her unwell.
I think that's a really valid point that you've made, that it is hard to become public about these issues, and there is a certain amount of privilege. And I think that's also something worth thinking through as we talk about strategic litigation. I just wanted to ask you, what are the kinds of arguments that you think have worked more in both moving courts and in moving the court of like public opinion, so in moving society's opinion? Is it the profile of the victims who were targeted? Is it the mass scale of the operation that has happened? Is it the drip by drip information that we have gotten? Since you studied this in so much detail, what according to you has moved the needle, both either like in the general like media moment or in courts?
That's a really interesting question, and I think there are two parts to it really. So if we look at the societal bit of it, it's actually really difficult because oftentimes there is a counter movement to discredit activists publicly and actually criminalize them and dehumanize them in ways that make sympathy and support for the case quite difficult and challenging. This is not to paint it as a bleak and totalizing picture that no one supports them, but it's really difficult considering that they have misinformation campaigns at scale and spread that's not afforded by civil society to counteract it. So one of the things that we've seen time and again is that activists really capitalize on this need for solidarity, that whatever they face, they can't face alone. And that's where our work comes in, advocacy for human rights defenders. In fact, that's exactly our mandate, speak up for them and protect them as they do their activism. So that's to answer the second part of the question. And in so many ways, it's really critical to be very open and supportive about the reasons why, like smear campaigns, they really cling onto very petty and unrealistic allegations. And here the counter narrative to this is basically to focus on what kind of claims about reform, what kind of claims about peace or empowerment or recognition of minority and immigrant rights should come into place. Now, when it comes at what moves the needle in the courts, I go back to the point that if you've noticed a pattern in most of these cases, it's based in democracies. It's not based in courts in the region, because courts in the region are biased against these groups, and they're never going to give a fair judgment of that. It's a combination of factors. So one is the readiness of the affected groups to actually go into court, to level a case, to present evidence, to go with it, because it takes a lot of time. It also puts them at much more risk than they would have had they stayed silent. In fact, most of the threats that they receive are accompanied by persuasions of the sort of, if you stay silent, we'll lay off you, we'll give you a break. But one of the things that we also noticed is the harm is not targeted. It actually trickles to other people, so family members, friends, acquaintances. And the spread of that harm is also something that motivates putting some kind of accountability to it. I think if anything, like these are cases that could drag on for long, but if anything, it's just to prove a point that it's not going to go unnoticed. It's not going to go, unscrutinized, and there should be something that's done about it. Of course, some people could at first express that they're interested in being a part of the case, but they roll back because they're tempted of playing it safe. And a win for someone who is brave enough and capable to go through the whole process is a win for everyone else. But unfortunately, it doesn't mean that it's the cost of being included in this is affordable to all.
Yeah, I think Pegasus really leaves a lot of questions and makes us think about things in a very interesting way. We have some questions from the audience, so I'm going to start with that, and then we can have some more follow-up questions. And I'd encourage members of the audience to sort of further keep on sending us their questions. So I'll start with Ellen Berkowicz's question. To what extent can this surveillance gathering and dark sales of data influence election disenfranchisement in the US? Sejal, I think this would be for you. Is the state-by-state approach to surveillance protections a situation that suggests local journalism has a new role in investigating this, and what might that be?
So, I guess I should start out by saying that our model is, my organization's model is movement lawyering. And so much of our work is informed by supporting and collaborating with community groups and organizing partners. And so I think in terms of, I think tools and interventions to really disrupt surveillance, like we think of litigation as a tool, but I think it's like most powerful when it's coordinated with organizing, federal and local policy advocacy, communications work, popular education, political education, storytelling, the building of communications. And so I think when used in combination, these tools can really help communities build power. And so, I mean, that is our sort of approach to sort of strategic interventions. I mean, I think that journalists play a very important role in terms of, you know, I think kind of where, you know, we get back to this question of the harms of surveillance can be very difficult to explain. I think technology, I think for a lot of people, just understanding the threat of technology is something that is not happening, right? Like the exponential threat of technology is a real threat to so many of our societies and communities, and but it's such a hard thing to explain. You have the tech, and then the harm is not always clear, and so I think that there is a real need for like organizing, but within that, public education, right? And so it's testimonies, it is like stories reports, it is fact sheets, and it's Freedom of Information Act requests. And I think journalists play a really key role in much of this, and this education piece, in asking the right questions, and they often have access to tools that others don't. I mean, when you think about a Freedom of Information Act request, you know, journalists can often obtain information, you know, much more quickly than the general public has. And I think when we have worked with journalists, for example, on the issue of electronic monitoring of, yeah, that's increasingly being used. E-incarceration is increasingly being used for immigrants in the U.S. I mean, they've really been able to elevate the issue in conjunction with, you know, centering community groups and the harms to communities. And they've also been able to talk to basically like whistleblowers, right? Like people who once worked for these private companies, who no longer work there, you know, who often are only going to be willing to talk to journalists. I mean, they're able to find them, and so I think that journalists have a very key role to play. And I wish that, you know, weren't so piece by piece in the U.S. It's just, unfortunately, there is a complete vacuum of, you know, federal regulation. You know, we don't have anything like the GDPR, and even states who have enacted privacy laws like California, they often don't give consumers or individuals the you know, direct right to sue. And so, you know, then you're once again sort of limited to state action. And so there is a real need for more regulation in the US.
Yeah, I mean, it's interesting you spoke about freedom of information requests. So at Internet Freedom Foundation, a lot of our litigation is also based on these right to information requests, as they're called in India. Although interestingly, we don't find that journalists necessarily have a better chance at getting information. Actually, the general public could get it pretty easily as well. So especially on facial recognition, etc., IFF has a transparency vertical, and they filed a lot of RTI requests and gotten information that has then formed the basis of strategic litigation on digital rights issues. The next question I want to ask, and this is open to whoever sort of wants to take it, is from David Brunello. So he says, do you consider that and it's a very important question, do you consider that for an individual, it will become increasingly difficult to start a legal action without the support of an NGO or with a class action? Does anybody want to take a, yeah, Nora?
Yeah, I would love to come in, because I think that's a really interesting question. And obviously, I mean, we're slightly, you know, obviously all of us on the panel are parts of NGOs. So, but I think, you know, in short, I think my answer, especially on these surveillance things, would be yes. It is harder. I think, you know, and Nadine obviously has spoken already too, and can speak more to how individuals are also put at risk with litigation, and that sometimes, you know, having the support of an NGO or having the support of sort of a group of litigants can be really, really positive and sort of a good safety mechanism, I think. And then the other thing is that, you know, what we said at the outset again about this collaboration, about the need to sort of coordinate with groups that are working on similar issues. If we're going to tackle what is a global industry, really, if we're going to tackle, oftentimes, you know, these systems, everything we've been discussing, you know, we've so clearly seen that it isn't happening only in the jurisdiction where we're going to court, right? It's happening in other jurisdictions as well. It's so again, having the connection with partners who are working on this in other jurisdictions, with, you know, being able to use those joint strategies and to rely on the expertise that is gathered by others who have either been there before or who are going through it at the same time. I think that that's really valuable, and that oftentimes is, you know, just resource-wise is something that NGOs might be better placed to do than individuals. So I think as sort of we increasingly take on a multinational sort of set of actors, we also have to work sort of in the strength of numbers as well.
Yep. In our experience has also been that if it's an individual, they often write to IFF and they say, like, look, we're interested in this, could you support us? So I think even if it would be an individual, you would sort of need maybe some support from an organization. So I think, you know, that helps. There's actually a follow-up question to David's question from Marina Mas. What do you see, and I think this is something, Nadine, you had also spoken about a bit, what do you see as the gaps in the use of litigation as an effective and equitable tool to use against surveillance laws? Do you have any recommendation on how to make the use of litigation in this area more inclusive and equitable? And I'd love to hear, you know, all of your views, some of your views, whoever, Nadine, maybe you could start.
Yes, absolutely. And I have to say, this is a very difficult question, because what would constitute inclusive and equitable here? I do work in democratic theory, and here I'll borrow some work from theory and say it's really about not discrediting people's grievances, lived experiences, harms, worries, and all of these things. When Sajal pointed out to storytelling earlier, storytelling is a very important thing. And it might not be the thing that you count as rational argument and something that's the classical form of making a solid case, but it is the case that we have here. So I think to make it more inclusive and equitable is that litigation should be more sensitive to not, sensationalization is a bit problematic, but at the same time to not discredit the emotional labor that goes into this, the impact on people's well-being that really needs to translate into making the case. On the question of how it's on equity, that's also a really difficult question, because if we link it back to the previous question on access, not everyone knows which organizations are out there, and the thing is, like, in so many of these cases, particularly those that we know so much about, is because they're activists, they're well known in their communities, they're well known to their networks, but some people, in some cases, people are just targeted for critiquing the government, and it's because they were venting online. So where do they go? Where do they take it? And here, I think it's just a matter of, it's going to be a long process, not something that's going to happen overnight, but extending networks of solidarity and expanding resource sharing, even though there are risks associated with resource sharing, but it's still a very important thing, and it's worthwhile investing in. So if you know communities that do this work, if you know litigators who are happy to do pro bono work, share it with other people who are interested in causes that you're working on. If you're doing risky work, if you yourself could be targeted for whatever reason and you have access to these resources, share it, don't be stingy about it. And at the same time, I think it would be good to say, just to be aware of the different aspects that go into starting litigation, because it's not an easy feat. It's not something that's it's going to be something that drags on for years, and that's probably not the only way of addressing grievances. One perk of working with NGOs and other organizations is that they have access to other mechanisms that address grievances. So maybe you'd get some sort of redress through something else that's not litigation.
Yeah, really helpful and thoughtful advice, I think, Nardine, to a very tough question. Nora, you had your hand raised.
Yeah, I just wanted to come in on that question from Ariana as well, about sort of the gaps in the use of litigation and how to make it more equitable, because I think it's really important to acknowledge the gaps, and especially with surveillance litigation and also these kinds of actors that we're talking about, be it governments or corporations. I think again, it's not something that can stand on its own, and also the difficulty in explaining the technology. And I know this is something that Sejal spoke to as well. Again, to the public, to explaining it to the court, and also the technology develops quite quickly, right? So actually, while we are going through the court process that takes years and years, things on the ground might look different. Things on the ground might change, might develop, and so I think those are all things that make particularly this area of litigation really difficult, and it also contributes to this aspect of it not being as inclusive and equitable, because the bringing in people into the fold, so to speak, in terms of their understanding of the litigation and the understanding of the causes behind the litigation, that is really difficult. And again, there, also what others have said in relation to working with groups, I think is really important. Really, Nubian Rights Forum and the way they kept the communities involved at the time that of the litigation in Kenya, it was really, really amazing. But it's a lot of work, and it requires resources. It's a hard thing also to explain to funders, I think. And so I think especially in this area, it is something that I think as a group we also just need to work on and need to find sort of systems to deal with that as well.
Yeah, thanks a lot. We then have another question from Daniel Leofa. One thing that was already mentioned in the potential confusions around technical definitions, we've seen this ourselves in a case where a company doing emotion recognition claimed they weren't doing facial recognition, just facial detection, which was factually wrong. What I noticed in working on this case was the difficulty of finding solid technical sources for the use of definitions. Is there scope for establishing sources like this for common types of surveillance that we are litigating against? Such a great question, Daniel. I wish it would have been great to actually hear more about your experience. If this had, if we could have been more interactive. And I'd just like to jump in before we open this up to our panelists. In fact, last year at RightsCon, one of the things, I was on a panel on internet shutdowns, because a lot of my litigation is also around shutdowns. And we had actually decided to try and come together to see if we could come up with a sort of global handbook in terms of different definitions of internet shutdowns and different experiences that people have faced. So I think it's a great question. But yeah, Sejal, Nardine, Nora, would anybody like to take a stab? Yeah, Nardine.
Thanks, Brenda. This is a really good question. It's definitely one of the key findings that we've had in the legal analysis of different cybercrime laws across the region. We've had a portfolio, and I'm happy to share the reports with anyone who's interested, since 2018 up until 2021. And what we see is that there's so many vague definitions, they're very overbroad clauses, and the potential here in some of the cases that I just named earlier is that if one sets a precedent that makes concrete norms around protections of human rights, that will be a really big win. But at the same time, this is what litigation is about, defining what's the problem and making a win. And so I think one part of our advocacy should be actually directed to prosecutors who are handling these cases, to make them aware of how these could be misused. What are the the existing, like we do a lot of mapping, we do a lot of documentation, and just give them evidence on why this is problematic and why there should be a public interest that's held up higher than these particular arguments in some cases. So in some ways, there would be the upper standard for potentially not setting a precedent that will implicate progress in protecting human rights through cases related to spyware and surveillance.
Yeah, thanks. Sejal?
Yeah, and I would just add, you know, obviously our experiences are going to vary jurisdiction by jurisdiction, country by country, but in the US, you know, we're again back to that 50 state scheme of where each state has its own laws. And so Illinois' you know, biometric law defines what biometrics are. You know, California has another law which defines sensitive information. It includes biometrics, but their definition is going to vary. And so unfortunately, you know, as Nardine was saying, you know, litigation is all about interpretation. And so some of this is just going to have to be duked out in court. But obviously, if there were, you know, a resource, a global resource, a global handbook that people could point to as sort of a model for interpretation, right? We have in the U.S. we have all kinds of model rules, and we often point to those when we don't have when there is no accepted definition yet. And so a resource like that can be very powerful. I would also say, you know, think about going back to your technologists. You know, for example, you know, like going back to the Clearview example, right? You know, at points they've said, well, you know, we can get around this Illinois problem by just by screening the Illinois photos. But if you talk to a technologist, you'll learn, well, actually, you know, many social media sites they scrub the metadata from the photos, and so that's really not that's not going to be an easy thing for Clearview to do. And so some of this is really just going to come back to the science and going back to our experts.
I mean, this seems to be an issue that's across jurisdictions. You know, so we've got another message from Lua Cruz, or Cruz. I'm sorry if I'm not pronouncing your name correctly, Lua. Vrinda, I don't know if it's the same case, but we at IDEC had a similar statement on a case regarding facial recognition in Brazil. A Sao Paulo subway line was doing emotion, age, and gender recognition, but when they were confronted in court, they claimed that they did not do any facial recognition, much less data processing, since they anonymized the data afterwards. Fortunately, we won the case in the first trial, but we are currently in the appeal stage. Again, would have been really interesting to hear more about about this litigation and how you sort of dealt with these objections. So, Lua, if you could maybe share that on the chat box, that would be really interesting for the users as well, I think. I do think this is a really common problem, and another related aspect of this is how you explain this to judges. In many cases, so in India especially, a lot of the judges in the Supreme Court are much older. So it's also about explaining technology, in a way, and even the senior counsels, in fact, arguing these cases are sometimes fairly senior. So I think it's about explaining and breaking down technology in a simple manner that can then be used to explain it to judges. We've seen, at least in internet shutdowns, because Access now does a lot of work around this, they end up having this sort of definition and glossary, which makes it easier to use. I think with facial recognition, just from the questions and everybody's answers, it seems there's a lot of disparate effect, like great litigation happening across the globe, but maybe we've not been able to learn from each other's learnings in as easily a manner. So I think that would be absolutely great. We only have 5 minutes left. So, okay, Daniel, it's the same case. That's great. We have one last question from Julie. This is a question for Nardine regarding what she said about sharing the research into cybercrime laws. Would you be able to share that, Nardine?
Yes, absolutely. There are 2 reports. If you give me a second to get them, I'll post these.
Great. And then Daniel said, here's the Access Now PR we did when IDEC won the case, although I'm sure Lua can share a PR from IDEC too. So thanks a lot. That's great. So 5 minutes to go. So any last questions, please type them in the chat box. Otherwise, I'll end with one last question for our panelists. Take your pick. How do you decide when is the right time to institute a case? do you think it's better if it's done in a strategic litigation manner by a civil rights group such as ACLU as opposed to individuals? And how do you decide who is the ideal litigant? So there could be support that is provided by an NGO, but who should be the litigant in court? And standing an issue that you encounter in your jurisdiction. So just sort of thinking through the strategic aspect of when you file a case, by who should be the petitioner or the plaintiff in the case, before which court or which jurisdiction. If anybody has any insights, I'd love to hear final thoughts from our panelists. Yeah, Nora.
Yeah, just one really quick thought, because it's an interesting point on standing. So Kenya, for example, has a really broad sort of standing provisions actually, and you can, which I know isn't the case everywhere. You can sort of, as an NGO as well, bring cases in the public interest. And I personally think that it's quite nice to do a combination of either NGO that is really sort of reflective of community, or NGO maybe and individual, because ultimately you would still need to show the harm, how it's occurring, how it's affecting individuals. It's really hard, I think, to show that when you're just doing it in theory as an NGO. So even when there are broad standing requirements, I would say that it's really valuable to have, that direct experience, to have those witnesses speak in court, and to be able to have that as a petitioner who brings that forward is really valuable.
Thanks, Nora. We apparently have a hard stop. So Sejal, I think the last comment may be yours.
Okay, no pressure. No, I think already we said that for us, it's in terms of like when we decide to bring a case, right? It is, I think the question is this part of a larger campaign that our partners are engaged in, that they've prioritized? Are we building a case in alignment with community, in coalition? And I think some of the things we consider is just, is there a path to a win here, right? And so that could be inside the courtroom, right? So you would need a viable theory. That is not always easy in the US with the lack of regulation, but it could also include wins outside the courtroom, right? Specifically, could the litigation be used to foster public education on the issue, to bolster the advocacy? Could it be leveraged to help with the passage of a local law or a policy? Like, would it bring a local entity, a local legislative entity to the table? And finally, is the litigation a tool to get key records, to get discovery that are really important to community partners? And so I think those are some of the other things we should be thinking through when we think about the potential benefits of litigation. And as Nora mentioned, our model is we often include individual plaintiffs alongside community groups, because community groups, just from a strategic standpoint, it's easy to it can be easy to moot out a case in the US if you just have an individual plaintiff and you take them out of the gang database. Boom, the harm is gone, the controversy is gone. If you have an organizational plaintiff, it's much more difficult to do that. But also, they are the communities that are impacted, and so they're leading the case, they're leading the communications work. But I think still, as Nora was saying, with an individual, you really have to be able to illustrate the harm. And so, we use that approach as well.
Thanks a lot. I think this is the end. So we'll just end with Christina's really amazing comment, not a question, just a comment, that it's great to see such an interesting panel with 4 amazing women working on this very important topic of accountability for surveillance, which has devastated the lives of HRDs who feel even more unsafe and whose well-being is impacted by surveillance, as Nadine said. I am just trying to send you the email IDs of all the participants in case anybody would like to stay in touch. It's been absolutely great having everybody, having you all. It's been a very interactive session. So thank you so much. We hope we were able to answer your questions and hopefully raise more questions. So thank you so much for your participation.